If you've been raped or sexually assaulted, no matter when it happened, Rape Crisis offers free and confidential support. It's your decision whether to report the attack. If you decide that's what you want to do, the first step is to call or visit the police.
My name is Donna Duffy and I'm a Sexual Offences Liaison Officer with the police, or a SOLO as it's called for short. I think it's important that I acknowledge how difficult this is for you to report this to the police, as I appreciate that it is very, very upsetting and distressing. However, I want you to appreciate that no matter who attacked you or how long ago it happened, that it will be taken very seriously and we will investigate it thoroughly. As a Sexual Offences Liaison Officer, I've been specially trained in relation to what evidence to look for when a woman or a man reports that they've been raped or sexually assaulted to the police. And I also understand the impact that rape or sexual assault can have on you and your family. I would need to take a statement from you, and what this would involve would be you telling me exactly what you can remember happened to you. What would happen would be I would write it down, and I would ask you some questions, and that would only be so that I'm clear in my mind as to what has happened to you. And in no way am I here to judge you. So we would take it at your pace. We can take a break if you want to take a break. The statement can be taken where you feel comfortable. It doesn't have to be taken in a police station. It's really important that you're honest with me and that you tell me everything that you can remember. We understand that there are things that you feel that you don't want to tell the police, such as you've been drinking or if you'd been in a previous relationship with this person before. However, none of that matters. You will not be judged whether you have had sex with this person before, whether you have been drinking, taking drugs. That doesn't matter. At the end of the day, you have been raped, and that's what we are here to investigate. There would be other officers involved in the investigation, and together we would be trying to gather as much evidence as possible so that we can arrest and charge the person who done this. Evidence can include things like taking statements from other people, obtaining evidence from where the attack happened, checking CCTV or anything else that we think is relevant. If your attack was a long time ago, don't let that discourage you. Still come and speak to us, because there are still lots of other ways in which the police can get evidence, and it would still be treated as serious as if it was a recent attack. At the end of our investigation, we'd let you know exactly what has happened, and if we have charged someone with rape or sexual offences, then what we would do is we would prepare a report which would be sent to the Procurator Fiscal. Understand how difficult it is to report a rape or serious sexual offence to the police, and one of the things that I can do is offer you a referral to Rape Crisis, who can offer you some emotional support through this difficult time. But what I want you to know as well, that as a solo officer, I'm here to support you and to guide you through the whole investigative process. If there are any questions that you want to ask me, then please feel free, pick up the phone, speak to me, we can chat through it, because what I want you to know is that you're not alone through this and we'll get through it together.
If you're reporting a recent attack, it's likely you'll be asked to have a forensic examination.
My name is Dr. Deb Wardle and I'm a sexual offences examiner. If you report a crime of sexual violence to the police, they'll bring you along for a forensic examination, and my job is to take samples that are going to help the police to do their job and investigate the crime. That will include taking items of clothing, taking swabs perhaps from your skin, what's been in contact with the assailant. It may include a genital examination also. The reason for taking those swabs is to try and identify the DNA of the assailant, to try and confirm the person who's committed the crime. What we will initially cover is the details of the incident. We're fully aware that you don't want to keep going through what's happened, so the police officers that bring you along will give me a summary of what's happened. Once I'm clear on the incident that's happened, I'll go through and recommend which samples will be useful for the investigation. I'll bring you through into the forensic room. Any clothing items we'll take, and you'll wear a paper gown while I examine you to look for injuries. Any injuries that require a swab, I'll use a cotton tip swab to take samples from there, and any sites that have been in contact with the assailant, I'll also take swabs. If a genital examination is required as part of that, we'll use a forensic gynae chair like this, which is in a well-lit area, so that I can take samples from the genital area to try and collect some assailant DNA. And I'll explain to you at each stage what's happening and just check that you want me to continue. If you want a break at any time, that's absolutely fine. If you're unable to continue and you want the examination to stop, just let me know and that'll happen. Something to bear in mind is the risk of sexually transmitted infections, which you might want to speak to the doctor about, or the possibility that you may need emergency contraception. If you're able to, try not to shower or bathe before you come up for your forensic medical examination. And the other way that you can help to get as much evidence as possible is to bring along things that you were wearing at the time or things that you've worn afterwards like pants, and put them in individual bags and bring them along to the examination. You may also want to bring things along like toothbrush depending on the circumstances of the incident. You may also want to bring sanitary protection that you had on at the time or afterwards, towels, liners or tampons in a plastic bag. Depending on the nature of the incident, the timescale for DNA remaining in certain sites differs, so the sooner you have the examination, the better. In general, we would say up to 7 days, but there are some situations, and depending on what's happened, where it will be less than that before evidence is there, and depending on what you do afterwards as well, will reduce the chance of finding DNA. If you decide that you want to have a forensic medical examination, we will gather good quality evidence to strengthen your case. I appreciate it's a really difficult decision to make, but we will make it as easy for you as we possibly can.
When the investigation is complete, a report is made to the Procurator Fiscal.
My name is Katrina Parks and I'm a Procurator Fiscal. I am a lawyer employed by the Crown Office and Procurator Fiscal Service. I receive a report from the Police Service of Scotland, who will have by this point thoroughly investigated the crime. So the report comes to me with all of the statements given to the police by yourself and by other witnesses. I then consider whether or not there is enough evidence to prove the crime about which you've told the police. When I look at the evidence in the case, I'm looking for corroboration. I have to have evidence that the crime was committed and evidence that that person committed the crime, and this needs to come from at least 2 sources. Once I've considered all of the evidence, I'll prepare a report and I'll make a recommendation as to what's going to happen with your case. I'll then send the report through to my colleagues in the National Sex Crimes Division. This is a team of experienced prosecutors, and they make the final decision as to what's going to happen with your case. If there is going to be a trial, the timescales vary as to when there will be a trial. This can be anything from 140 days if the accused is in custody, or 12 months if the accused is on bail. After the accused has made the first appearance in court, you may be invited in for a meeting with one of my colleagues from the team. At this meeting, you will be asked questions about your statement you gave to the police, and we'll ask you further questions. It's also your opportunity to ask us any questions at that point. During the course of the precognition investigation, one of my colleagues may need to meet with you to seek your views in obtaining your personal records, for example, your GP records, if you were injured as a result of the crime. It's important that you know that that doesn't necessarily mean that you will then be asked questions about your records or this personal information in court. You can't be asked any questions about your sexual history or your character. You should be aware that if this evidence is considered relevant, then the defence or the Crown can make an application to the court for questions to be asked about that particular area of evidence. During the course of the precognition investigation, you'll be invited in for a meeting with one of my colleagues from Victim Information and Advice. They will speak to you about support that you may feel you need to give your evidence in court. For example, you may consider that you'd better give your evidence with the use of a supporter in court, or with the use of screens, or in fact by giving evidence out with the courtroom by use of a CCTV link.
Some cases don't ever go to court.
If a decision is made to take no proceedings, this is usually because there is insufficient evidence to proceed. This does not mean that we did not believe your evidence. Victim information and advice is a dedicated service for victims of crime. The aim of VIA is to provide you with information about the criminal justice system in general and about the progress of your case.
If the case does proceed, you'll be asked to meet someone from the accused's defence team. You can choose where to meet them. It could be at Rape Crisis or at the lawyer's office.
My name's Sarah Livingston and I'm a defence counsel. My role in any trial is to represent the accused person. That's the person who you're accusing of sexually abusing you in some way. The process can be very confusing when you make a complaint of sexual abuse. It's important to know that it's really not like television. An accused person is presumed to be innocent, and so the trial proceeds on that basis, and the prosecution have to prove his guilt. To do that, you're going to have to be questioned, cross-examined, and various witnesses are called. And it's not a straightforward position where you simply say, this happened to me, and he's carted off to prison. Sometimes the defence will ask you to speak to them. That's called giving a precognition. The person who will take the precognition will either be the solicitor who's acting for the accused, or someone that the solicitor has asked to take that precognition, usually called a precognition officer. The purpose of it is to find out exactly what you're saying about the crime, and sometimes that means that it will result in a plea of guilty. Other times it will mean that there are further inquiries to be made depending on what you've said. The precognition can really occur any place. Sometimes it will be at the solicitor's office, but the important thing for you to know is that it can be a place of your choosing. No one's going to force you to go anywhere that you don't want to go.
If your case goes to court, it can help to know what will happen. The Lord Advocate is the head of public prosecutions in Scotland. He's not someone you're likely to meet in court, but he has responsibility for all prosecutions.
I'm Frank Mulholland, the Lord Advocate of Scotland, Scotland's Chief Prosecutor. Well, when you're called into court, you'll be taken to the witness box where you'll give your evidence. To the right, behind me, you can see what we call the bench. It's where the judge sits. And facing you, you'll see a jury box which contains 15 members of the public. They are the triers of fact. They will hear your evidence and make an assessment at the end of the day as to whether the case is proved. And you'll also see a lectern where the persons asking you questions will stand and ask those questions from. There's a large table, it's where the clerk and the lawyer sit, and you'll also see the public benches. Don't worry, in a rape trial the public benches are cleared of members of the public. Your address won't be given out in open court. Your address will be given as care of Police Scotland, and also the paperwork which is provided to the defence solicitors will not disclose your address. Well, if you need a break, ask for it. Ask the judge for it, and the judge will grant you a break. Whatever you do, don't carry on if you don't feel as if you can carry on. The best way to deal with it is to ask the court for a break, and I'm sure the court will respect your wish. A judge is there to ensure that proceedings are conducted fairly, that witnesses are treated with respect and fairly, and that there's no oppressive or unfair cross-examination. A judge will also ensure that any evidence which is led in the trial is relevant evidence and will rule inadmissible any irrelevant evidence.
Before the trial begins, you can meet with the Advocate Depute. It's helpful to do this at the court.
I'm Kath Harper. I'm an Advocate Depute. Advocate Deputes prosecute in the High Court. As an Advocate Depute, I prosecute in the public interest, that is, in the interest of the people of Scotland. When you come to court, I, as Advocate Depute, have brought the case to court, and I will ask witnesses questions. I prosecute in the public interest, and so you will be a witness from whom I take evidence, but I am not your lawyer. I will not be your lawyer as such. The person who you say attacked you will be legally represented. In other words, he will have a lawyer, and that lawyer will have the opportunity to ask you questions. Usually I would meet you in the week before the trial. Ideally not on the day of the trial, but in the week preceding the trial. And I think it would be best if we met at the courthouse, because then at the same time you could see the courtroom in which you were going to give evidence. And having met me, you will then have a familiar face when you step into court. What I would say to any woman or man who's a complainer in a sexual assault case is bear in mind that the meeting in the week preceding the trial is the opportunity to sort out any problems. So think about any concerns or anxieties you might have, and we can discuss them at that meeting and find solutions.
On the first day of the trial, you'll be asked to return to the court to give evidence.
When you come into court, you'll see the time there. The first thing that you'll be asked to do is to stand up and to take the oath. The judge will put you on oath. And after you've been put on oath, I will then ask you some questions. I want you to tell your story to the jury. And I do that by asking you a series of questions. And so by this series of questions and answers, the jury will understand what happened to you in this particular case. Now, after I've asked you questions, the accused lawyer will have the opportunity to ask you questions and to put the opposing account to you for your comment. And after you've been cross-examined in this way, I may ask you some further questions. I may not. And indeed, the judge may ask you a couple of questions, but may not. If you don't understand a question, it's generally the fault of the lawyer who's asked a question badly. So don't worry about not understanding a question. Just simply say you don't understand, and it will be repeated in a different way. If you don't know the answer to a question, simply say, I don't know, don't try and guess, because you won't always know the answer. And if you become upset at any time, then please be aware that at any time you can ask the judge for a short break.
The accused's lawyer will ask you questions.
When you come to court, my role will be to cross-examine you. That is, to test your evidence. And I'm doing that because the accused person will have given me his account of what happened. If I don't put that to you, if I don't test the evidence, then I will be in trouble with the judge, and there's a possibility of an appeal because he hasn't been properly defended. It's just part of the process. There are two different sides to this, and each person has to put their side so that the jury can determine which one they prefer. For example, if you say that you didn't consent to something and he says that you did, I will have to suggest that to you so that you have an opportunity to comment on it. You might be worried about the sort of things I'll ask you in cross-examination. The important thing that you should know is that I'm not entitled to ask you anything I like. There are very strict rules about what you can be asked. You don't have to worry about me springing anything on you. If character evidence comes up, you will know about it in advance because the Procurator Fiscal will have given you notice of it. You absolutely should not take it personally if you feel under attack in cross-examination. All I'm doing is my job, and all I'm doing is putting forward my client's instructions. Remember that I am there to test the evidence, to test your evidence. But you should also remember that the judge is there to make sure that the trial is run fairly, and you won't be treated in an unfair way because the judge would intervene. If I ask you a question that you don't understand, you simply say that you don't understand it. The judge is also there to make sure that any questions I put to you are in clear, plain English, and the judge will stop me if I ask you questions that are overly complicated. It's very difficult to know in any trial whether or not an accused will give evidence. It really just depends on each case. The important thing to know is that although you're obliged to give evidence, he is not. Before you come to court, everyone you will have met will have been on side, will have been sympathetic towards your position. But you must remember that's not my role. My role is to defend the accused who says that you're lying, who says that he is innocent. So when I ask you questions, they'll be in a very different way and in a very different tone, and you should expect that. But bear in mind the judge is there to make sure that everything happens fairly, and I won't be allowed to badger you or harass you. The judge would intervene.
After you've given your evidence, you may leave the courtroom.
After you've given your evidence, I will call a number of other witnesses in support of the case. And the same process will happen with each of these witnesses. They will be asked questions by me and cross-examined by the defence. At the end of all the Crown witnesses, the witnesses for the prosecution, I will then close the case, and that is all the evidence for the prosecution. After that, the accused may give evidence, but the accused doesn't have to give evidence. It's his choice. But if he does give evidence, he will be asked questions by his lawyer, and I will have the opportunity to cross-examine him. Somebody will keep you advised about what's happening during the trial, and they will tell you what the verdict is once the jury have delivered it. After that, if you want to meet me, I would happily meet you to explain to you what happened in the trial afterwards.
Back to the Lord Advocate to find out what happens at the end of the trial.
At the end of all the evidence, the judge will sum up the case to the jury. That's a process whereby the judge gives directions on how the jury should approach their task in deciding the verdict in the case. There are 3 verdicts open to the jury, 2 verdicts of acquittal, that's not guilty and not proven. Both are final verdicts, and the verdict of guilty, which of course results in a conviction. If the accused is found guilty, then the sentencing process commences. The judge will obtain the necessary background information. There is no set tariff for a conviction for rape. It's really a matter for the court, having heard all that information and considered it, to determine the most appropriate sentence. Sexual crimes, including rape, are treated very seriously. They're dealt with by very skilled and able investigators and prosecutors. You'll be treated with dignity and respect throughout the criminal justice process. It doesn't matter if a period of time has elapsed since the crime perpetrated on you. It doesn't matter if you're a man or a woman. It's all about delivering justice, and that's what we're here to do.
The justice system can be a difficult process. At any stage, you can call Rape Crisis for free and confidential support and information.